This is evidence outline. Book notes, continuation of chapter 9, which is, I'm not sure if I started that yet. Ultimately, I have 10 more pages of book notes to brief. We're about 75% of the way done our outline, and we're on page 66 of the outline. At some point entered into chapter 9, potentially. Right this very instant. Okay, so we're going to start with some new material. Chapter 9, Opinions, Experts, and Scientific Evidence. Risinger Treatise. Okay, we actually did start chapter 9 already. I just didn't label it as a new chapter. Apologies. So we started that long ago. FRE 701 allows lay opinions that is rationally based from firsthand perception and helpful for clear understanding. 704 does not. Find lay testimony objectionable because it embraces an ultimate issue to be decided by trier of fact. 702 is about distinguishing between the lay and experts. I'm a little bit iffy on what and why. FR3 is the types and data sources for the expert. 704 is to avoid conclusory opinions of experts. 706, court-appointed experts, and talked a little bit about the polygraph. And so returning to the Risinger Treatise, what is that exactly? Researchers looking for empirically defensible constructs of reality. Therapists, committees to help their patients regardless of objective reality, of patients' particular account. Committed. Social policy advocate for the groups to which patients are perceived to belong. Example, battered women syndrome. Example, PTSD. Example, child sexual abuse accommodation. Available to show reason for delay, not existence of crime. Lacks foundational standards. Slobodin treatise. This is a kind of 3-part continuum of 5 years before Daubert and 5 years after Daubert. It shows how before Daubert there was less admission of all of these, what we called groups which patients are perceived to belong. However, after Daubert, there was a greater admission of mental disorders, battering, rape, syndromes, intent, child molestation, dangerousness, truthfulness of victim, child sex abuse victims, half of these are crossed out. I list them all here, but in my outline, I'm going to cross out what I crossed out, which was battering, rape, child molestation, and truthfulness. I'm not understanding the point of this, but again, it's just a treatise. Next part. Probabilistic evidence. A probability primer. I'm going to say for the recording, as I type all this out, that these are actually a series of equations where probability of X is P X in parentheses, P squiggly X equals the probability of the opposite of X, i.e. not X. P in parentheses X dash Y equals the probability of X given Y, which is conditional probability. And these are all just kind of basics. The next page is, it's a lot. Odds equal Px divided by P parentheses squiggly X meaning not X. So that's what odds are, the probability of X over the probability of the opposite of X. And a definition for odds other than the equational one is the probability of a thing divided by the opposite of the, just end it there. And then the example was really good though. It was like pick one card in deck. That's 1 divided by 52 divided by 51 over 52, which equals 1 over 51. Technically are the odds of picking one card in a deck. And there's the concept of independent probability, which is if we know that card was already selected by not what suit multiple multiply independent probabilities. Okay. Multiply independent probabilities. Independent probabilities. Multiply. Goodness. Only a little bit more here. So the way that you demonstrate multiplying independent probabilities is by doing the equation of P parentheses X dash Y times P parentheses Z dash Y. Probably an or X over Z, actually. I'm like having a hard time finding where I am on the page. And that is for probability of both things happening. So that's why we multiply independent probabilities. Okay, so the example prod rule is probability of picking hearts and probability of picking a jack. Dependent probabilities as long as independent, prod rule alternate if dependent so the equation, I'm not really sure if this relates to independent or dependent at this point in time, but the equation that goes along with that language is P parentheses Y and Z equals P parentheses Y times P parentheses Z dash Y. And the caveat here is that I don't know if that has to do with dependent. I think I'm going to say My notes are just hard to read. So I'm just going to say the caveat to all of this is that a deck of cards is a closed universe, which is genuinely not the case in real cases. So we kind of move into, thankfully move past that. This is probably the most difficult part of the book. Trial by mathematics preceded by Bayes' theorem. People, Cousins, Collins, California, 1968. So that case was already briefed. So what I'm going to do is I'm going to drag it down to that section. And continue. Collins stimulated some interest and can serve as a guide for juries like 1 to 1,000 people could have used murder weapon but also has propensity to confuse jury by dwarfing in all variables DNA testing, U.S. versus Davis, bank robbers had to have Jeep behind and were found out by prints on guns that had DNA, considering statistical significance at length. Case Kohler treaties, coincidental matches are usually small with DNA. False positives are impossible. Proficiency test data subject to human error. How to convey to jurors is biggest debate on DNA. Judicial reluctance because likelihood of entering flawed method. Methodical approach. Privacy. Proprietary secrets. Murphy treaties. Data mining. Geolocation tracking. biometric scanning, second generation forensic sciences, Roth treaties. When is DNA only enough to convict? (1990s) data banks led to lower number of cold hit prosecutions, contamination, interpretation errors, legally insufficient, mistrust, fallacy of the transposed conditional. Traditional forensic science. Case, U.S. Handwriting expert on insurance forms no longer prevails per Daubert criteria. Sachs Ipse-Dixit treatise. Not much use of forensic identification science before or after Daubert. For example, empirical support or lack thereof. Harry Fould's finding that highest scientific certainty shows two fingerprints can never be the same. Cole treatise. Cole treatise. How likely are partial or latent fingerprints to identify wrong person, wrong source finger? And there's a case from Britain called McKee that caused Britain to abandon the 16-factor similarity approach. Britain matching ridge characteristic points of similarity was quantified. US. Rely on experts. An estimated margin of safety, which is unqualified. Handwriting analysis, a science at all, if 45% unreliable. Post-Daubert scrutiny high. Treaties. Okay, there's going to be several cases that I'm going to go over before the next, there's only 4 before the next book notes. So one we already did, which was Fiji. There's U.S. versus they say. Just put it at the end of this section. Case number are we on? We're on case number 179, actually. 179 U.S. Defendant burns down his houses for insurance money and kills his wives for life insurance. Probabilistic evidence entered. Even when other evidence is overwhelming. Because any error is harmless by totality of the circumstances. Body of evidence. We briefed Davis, so that'll be 180, case 180. And after that was U.S. versus Graves, which will be 181, which leaves Fiji, which we briefed already as 182. What's going on in Graves? It's another bank robbery. I love bank robberies, kind of. Case 181. One. U.S. Armed bank robbery indictment. Defendant using firearm during commission of violent felony. DNA from discarded umbrella. Sneaker tread from teller counter. Matching sneakers seized later. DNA samples were all admissible. Case Commonwealth. Case Skalansky Treatise. No code on forensic science for criminal or civil law. Fingerprinting, ballistics, handwriting, hair, bite marks, etc. Chapter 10, privileges. In general, no objection to intro of evidence at trial. Objection to compelled disclosure. Not always overlap with duty of confidentiality. FRE 501. In criminal, efforts to continue to develop and apply common law privileges. In civil, matter than procedure. McCormick on evidence. Unlike most evidence to elucidate truth, the privileges are inhibitive, socially beneficial, protect relationships viewed as sufficiently important interests. Mueller. Examples. Executive, lawyer, client. Psychotherapist, patient, spouse, clergyman, penitent, political vote, trade secrets, state secrets, informants, journalist source, physician patient, article overrides state privileges. Instead, 501 attorney-client privilege, controversial, zealously debated, coveted because justices were first lawyers. Bertham, 1827. pretty language justifying the attorney-client privilege because legal advice would be limited and attorneys should not be compelled to betray by immoral treachery the confidence reposed him. Simon Treaties discussed instance when attorney-client privilege protected or exacerbated or obstructed or evaded Keating perpetuate 31 billion in fraud losses at Lincoln Savings and Loan by directors and officers covered by FDIC and Office of Thrift Supervision. Received misconduct restitution from lawyers is to dissuade. Now point of model code of professional conduct. Outcome more aligned with social interests. Barton Treatise. Attorney-client privilege. Most vaulted privilege. Justice sensitivities. Of the privilege. Communication in confidence between lawyer and client in course of providing legal services. Not waived. Privilege belongs to the client and is waived by client's failure to keep communication confidential unless attorney does so outside acting agent. As an I think in the interest of time, I'm going to or maybe I'll try to shorten them to just what is the importance. So let's see. Case number are we up to? 1998 stands for the idea that congressional summons to lawyer's client or communication arose as a response to a congressional summons to the lawyer's client about some political affair. And um the client, Foster, commit suicide after confidential communication. The confidentiality outlives the attorney. And there's a lot of reasons for it. I think that's where we reach, though. I wonder, yeah, okay. There's some TV show about this case, or not about the case, but the case comes up in it. Case number 185, U.S. v. Chikarla Apache Nation, 2011. I wrote here, Native American claim breach of trust action against government trustee from Indian Trust Fund. Management Reform Act of 1994. ACP asserted over organizing documents. And 501 rule, ACP shall be governed by the principles of the common law. Lends court to review up John for to determine in light of reason and experience that ACP is the oldest privilege at common law for confidential communications. In other words, the documents remained confidential. In 186 U.S. Kendrick. I'm just going to take a short 501 definition. It was best put here. 501 directs federal courts to continue to develop and apply common in light of reason and experience. I'll just kind of add. And that's probably the best definition for it right now for the purpose of the test coming out. In Kendrick, what happened? Attorney subpoenaed to discuss observable competency, not any substantive matters. Which are Demeanor and attitude are for cooperativeness, awareness, that are readily observable are not privileged information. Seven, U.S. Ninth Circuit, 1988. Tax investigation involves subpoena on the defendant's tax trial. Court denied motion to squash. Held attorney fees sought by IRS. ACP only when necessary to effect its limited purpose of benefiting the public's interest in forthright communication. Case 188, U.S. Defendant, driver of yellow Mustang in bank and $18,000 in traveler's checks by issued, yield, sawed-off shotgun and ammunition in commission of crime in his car. Defendant called his lawyer within an earshot, which constitutes a waiver of the attorney-client privilege. Because the defendant, whoever claims the privilege has burden to show the communication was made in confidence. Case 189, U.S. Evans. The government motion to admit coach testimony. The defendant is a Chicago politician, alderman, who sees Holden, who recommends coach and accompanies him to consultation with coach as a friend and character witness. Therefore, destroying prong of prong. Case 190, lawless. IRS subpoenas attorney preparing estate taxes. ACP asserted, but not applicable because tax preparation materials ought to be known to be rendered to the government when requested. Trial court reviewed in camera and considered the documents to be privileged. The appeal court reversed that determination. Case 191, SmithKline Beecham, Apotex Corporation, $2,000. Motion to compel production of documents in privilege log. Found to be immune from discovery by attorney-client privilege. Patent. Historically, patent documents are prepared in consultation with a lawyer, attorney, as the conduit between the patent and the patent office. An attorney cannot evaluate patentability or prepare a competent patent application without knowing the prior and obtaining the relevant technological information from the inventors. Invention. Patent uniquely defeats evokes attorney-client privilege for these reasons. Evokes. Evokes. Lower court decision overruled. Case 192, U.S. Koval. Grand jury subpoenaed Koval appellant non-lawyer accountant employed by a law firm to testify about firm's clients 2 days before statute of limitations and contract claims privilege. Non-lawyer accountant. At grand jury. Before grand jury. District court administers contempt as a punishment for 1 year with no bail. Grand jury gives bail while appeal on issue pending. Supreme Court vacated and remanded to determine purpose of advice. Supreme Court advises that non-lawyer employee communication with legal client of firm may be protected for legal services, but not for sole purpose of receiving accounting services. Based on a historical analog and Wigmore, Section 2290 and 2301, privilege must include all persons who act as attorney's agent, such as a translator, secretaries, file clerks, telephone operators, messengers are indispensable to support attorneys to effectively handle clients' affairs. Wigmore's 8-part formulation grand jury. One, where the legal advice is sought. 2, with legal advisor in his capacity. 3, communication for that purpose. 4, made in confidence. 5, by the client. 6, are at his instant permanently protected. 7, from disclosure by he or legal advisor. Insistence. 8, unless warranted. Case 193 U.S. Case 194, Pastries. Pastories. Plaintiff fell down defendant's steps, suffering injuries, brings action for recovery of damages. Plaintiff sought transcribed statement given by defendant to insurance company. Defendant contends insurance agent subordinate of attorney and claims attorney-client privilege because insurance company is defending him. The communication must be to a member of the bar in a legal capacity, and therefore the subordinate of an attorney cannot meet that requirement to achieve attorney-client privilege. Achieve. Case 195, Hughes. Mead. Attorney, writ of prohibition of order, testify to comply with summons to petitioner is an whose judge demands attorney identify name of client who hired him in non-legal custodial capacity to return typewriter stolen from authorities. Attorney-client privilege does not apply to custodial, depository services. To protect identification from prosecution. To hold that it does would contravene the doctrine and subordinate criminal acts contrary to public policy. Case 196. U.S. Davis. Attorney opposes IRS summons to produce documents prepared in regarding attorney's client's tax liability. Documents in attorney's possession for when lawyer is acting as accountant do not constitute legal services, and there is no accountant privilege recognized in the federal court system. Case 197, U.S. Bernard. Defendant convicted of 62 counts of making illegal nominee loans. Nominee. A third-party victim testified saying the defendant told him he cleared the loan's legality through his attorney, which serves as a waiver of any privilege of confidentiality between the defendant and attorney, and permits subject matter of communication to be compelled of attorney. Attorney clarified that was not the subject matter of their communication. ACP cannot be claimed because of waiver. Convictions upheld. Case 198. Cause of action was interstate kidnapping, and defendant's attorney advised he not testify. In present case, defendant brings a malpractice cause of action which is overrides ACP by bringing issue on subject matter of attorney-client communication in an attorney competency misconduct action. The defendant is not entitled to ACP. An attorney can testify to contents of communication to defend himself and his credibility. Competency from the client's claims. Client's claims. Client's claims. Case 199. City Housing Commissioner appointed by former mayor, who is Powell's predecessor, is bringing an action against the city and the mayor, challenging legality of appointment of housing commissioners and arresting them at assembly. Mayor refuses depositions. And attorney, therefore, did not protect. Engaged in. With present, but attorney failed to privilege. ACP cannot be invoked because it was already waived at trial for depositions. And burden of proof of ACP was not met. After motioning to quash depositions and protective order, the mayor was compelled to honor depositions. The affirmed. Case 200. Request valid to all communications, but appeal court reverse as it pertains out of 4 unprivileged. Book being published, defendant waived. Decedent's children bringing a civil action against decedent's husband and seeking to admit attorney-client communications from attorney for defendant the waived court held that because some privileged information was waived does not mean that all privileged communications are subject to discovery. Their holding was based on the disclosure of attorney-client privilege to what was published and no more, not for communications that have not been published. Identity of client is not generally protected, but it can. ACP FRE 501 treaties circumstantial evidence of charts intent at time of attorney client privilege disclosure. Reasonable steps by holder or attorney as agent to protect can be determinative. Crime fraud exception. Legal services to further a crime or fraud do not qualify for ACP whether or not attorney knows that is the purpose. Spousal privileges. Protection against disclosing confidential spousal communication during marriage. Protects against adverse spousal testimony. CEC 970. 87. Case 201. So there's 3 more cases before we get into another bout of book notes. And almost thinking that could be the last bit of book notes. I'm just checking. Doesn't seem like I went through that many, though. No, there's physical evidence. And we're going to go through authentication and best evidence rule. Maybe it's rather short. So there's going to be 4 more pages. Okay, 6 more pages of book notes. Let me finish before going into the 4 privileges chapter and return to cases. Just as quickly as we can. Spousal privileges. Spousal privileges. Privilege against disclosure of confidential spousal communications. You said this. All right. I already said this, so I'm just going to copy it down. I think. Privilege against adverse spousal testimony. See case Trammell. U.S. Other privileges. States afford husband and wife, ACP, and some recognize priest penitent privileges. FRE 505 characterizes confidential communication to a clergyman in his professional character as spiritual advisor. Waivable by communicant in majority of jurisdictions. Waivable by clergy member in minority of jurisdictions. Waivable by both in minority of jurisdictions. journalist, source, and government informants privilege. Both rejected in case law and or congressional legislature. Case law. Con law case. Qualified journalist privilege may be penetrated by appropriate show. Sexual assault victims counselor privilege. Medical review privilege, subject and self-trial analysis from Go Therapy, etc. And I'll break there before getting into authentication and best evidence. Hopefully we're still recording.